have a couple. First of all, the minutes from last week will be on the S drive by the end of today. And my second announcement is a little birdie told me it's the vice chair's birthday today. So let's all wish him a happy birthday. We won't, oh, you don't want to hear us sing. Do you want us to sing?
No.
Oh. That's all right. We don't, yeah, I don't have Barbara Ballard here to lead us. Yeah, you can all.
I want to be old.
It beats the alternative. Yeah, beats the alternative. Okay, so we're going to start off today opening up a hearing on House Bill 2629, and we'll ask Jesse to give us an overview.
Thank you, Madam Chair. Good afternoon, committee. House Bill 2629 was a bill requested by the Attorney General's office the other week when they were doing the State Child Death Review Board annual report review. So House Bill 2629 amends multiple statutes that are related to the State Child Death Review Board, review of child deaths, the records, and coroner and law enforcement protocols. So Section 1 amends KSA 22A 242, which is a statute that governs procedures for a child death. The bill eliminates the requirement that the coroner sign a non-suspicious child death form after an investigation and autopsy. Additionally, the coroner would no longer notify the board within 30 days of the investigation and autopsy. The coroner is currently required to attempt to notify any parent or legal guardian of the child prior to an autopsy. And this bill keeps that in there, but it would also require that such notice shall contain certain information about the autopsy and instructions on how to obtain a copy and the finding and the results of that autopsy. A new subsection is found in this, and it would require the Secretary for Health and Environment to provide a copy of the child's death certificate to the State Child Death Review Board. Section 2 amends 22A 243, which is a statute that establishes the board. So this proposes that the board membership be increased to include one more member appointed by the State Board of Healing Arts, and that person be a physician licensed to practice medicine and surgery, specializing in pediatrics. There's a new subsection here that you can find that states that the charge of the board is to review all child deaths in Kansas, of Kansas residents under the age of 18 and non-residents under the age of 18 who did die in the state of Kansas. This section would also allow for compensation and subsistence allowances for the board members, subject to the approval of the chairperson and the Attorney General. The bill would also add a new option for disclosure of board records, and that could be to any person or entity if the information and records being disclosed are statistics or conclusions of the board provided for the purpose of procuring and maintaining financial grants. So those are the types of entities that the board could choose to disclose records to. And then the last section, Section 3, amends KSA 22A 244, and it directs the state board to maintain records for at least 15 years after the date a case is investigated by the board is finally closed. The section would no longer require that the board transmit a copy of the board's written report to the county or district attorney of the county or district in which a child was a resident or where a death occurred. And that is the bill brief for House Bill 2629.
Okay, do we have questions for Jesse regarding the bill? Representative Johnson.
Thank you, Madam Chair. The current membership on the group, the Death Board, could you share that with me again? I'm curious on the numbers.
Definitely. So Representative, the board is comprised of one member appointed by each of the following offices. So one by the Attorney General, the Director of the KBI, by the Secretary of DCF, by the Secretary of Health and Environment, and the Commissioner of Education. And then there are currently 3, the proposal is to be 4. So currently 3 members appointed by the State Board of Healing Arts, and then there's certain requirements for those, that one of them be a district coroner, and 2 of those be physicians licensed to practice medicine, and currently 1 specializing in pathology and 1 specializing in pediatrics. And then 1 person is appointed by the Attorney General to represent advocacy groups that focus attention on child abuse awareness. 1 county or district attorney appointed by the Kansas County and District Attorneys Association. and that is the membership. So math-wise, it looks like 1, 2, 4, 5, 10. And of course, the board can check me on my math on that.
Okay, follow up. So the one on the advocacy group, is that a specific advocacy group, or who makes that decision to appoint that person?
Yes, so that person is appointed by the Attorney General, and then the language of the current statute only says that that person is to represent advocacy groups that focus attention on child abuse awareness and prevention.
Excellent, thank you.
Further questions for Jesse? Okay, thank you. So we'll open up the proponents, and first we'll have Sarah Hortenstein. Are we having both of you? Just okay.
Representative Concanon and members of the committee, thank you for the opportunity to testify in support of House Bill 2629. My name is Sarah Hortenstein, and I serve as the Division Chief for Youth Services at the Attorney General's Office, as well as the Executive Director of the Kansas Child Death Review Board. As a brief overview, the State Child Death Review Board was created by the legislature in 1992 and is administered by the Office of the Kansas Attorney General. The board examines the circumstances surrounding all children under the age of 18 who die in Kansas, as well as the deaths of any Kansas children, when notified, who die in another state. On average, the board reviews nearly 400 child deaths per year, which includes an analysis of the children's medical records, law enforcement information, autopsy findings, social service history provided by the Department for Children and Families, school records, health records, and other pertinent information that is used to evaluate this child's death. Through the extensive and comprehensive reviews, the board is able to identify and understand the circumstances regarding the child at the time of their death and those circumstances leading up to their death. From there, the board collects and analyzes our data to identify patterns, trends, and risk factors related to the deaths so that we may inform public policy within our state. Given the board has been in existence for over 30 years, it's reasonable that some of the statute that was originally drafted in the early 90s might need a bit of freshening up. So as introduced, House Bill 2629 will modernize the outdated language as well as codify some current practices and notifications between our board and coroners, as well as other agencies such as KDHE and DCF. In addition to general cleanup of statute, House Bill 2629 has two provisions, both of which have a positive impact for our board members. The first provision would authorize an additional appointment from the Board of Healing Arts. This would add some additional pediatric expertise for the review of these deaths, as well as ensure that overall case assignment is at a manageable level for each of our appointed board members. The second provision would allow compensation for board members to attend our monthly meetings. This is consistent with other practices of state boards and also addresses some barriers we have found as it relates to finding suitable appointment to the board when an interested party may live sometimes several hours from the location where we host our meetings. Lastly, as introduced, House Bill 2629 will allow the board to disclose statistics or conclusions for the purposes of procuring and maintaining financial grants. This added disclosure will allow the board to meet our federal funding requirements of some of our existing grants, as well as ensure competitive application to future grant opportunities. Now, not included in this bill, unfortunately, is our request to amend KSA 22A 243J to add an additional disclosure allowance that would allow the board to disclose information and records or statistics and conclusions that we weren't able to provide in our annual report to the governor and the legislature. I have included that exact language in my written testimony for your guys' consideration. Currently, our state statute restricts the board from disclosing any conclusions or statistics outside of the board's annual report, which we submit to the governor and the legislature on or before October 1st each year. The requested amendment would allow the board to keep our annual report at a manageable length without having to compromise the level of information, statistics, and data we report out to the public, as well as committees such as this. We would appreciate consideration to add that language to this bill. In conclusion, the work of the board is absolutely commendable and needed to ensure that as a state we are aware and responsive to risk factors associated with child deaths. As written and with the additional amendment requested, House Bill 2629 is important to the overall success of the State Child Death Review Board. With that, I'd be happy to stand for questions at the appropriate time.
Okay, committee, do we have questions on the bill? So the language that you have in your testimony, I've been trying to get to it here, that would be a proposed amendment. That would be a suggestion for a proposed amendment.
Yes, it just did not make it into the bill before it was introduced, but it is something we feel is very important. And with the information that has been requested out of this committee that sometimes just hasn't made it in our report due to prioritization and ensuring that the report is not 200 or 300 pages in length, we do our best to give as much information as we can. And this would just help us and have additional reports to the governor and the legislature so that we can keep giving good data and not have to prioritize that for one report each year.
Okay, do you have a question? Representative Wagner.
Thank you very much, Madam Chairman. You mentioned in your testimony that the Attorney General's office would get some additional revenue from this, and I was wondering about that. And then also, there's not really a fiscal note attached, though obviously adding people, paying all their expenses and such is going to incur some expenses. Can you elaborate?
Sure. Our fiscal note provides that there will be additional cost to compensate board members for mileage and some of those expenses that the revisor discussed. However, the office's opinion was that we could absorb those costs, so there wouldn't be an additional request of monies for that. In terms of being able to generate more revenue, there is potential for that. So currently, the State Child Death Review Board is a recipient of a CDC grant. We receive a little over $100,000 a year for the next 5 years to do some of the work related to sudden unexpected infant deaths. Some of those funding requirements require us to remit some sorts of information that this bill would address our allowance to do so. With the ability to apply for more grants that are competitive in nature, sometimes you do have to give information that maybe would occur before our annual report is published, meaning if a deadline happens before then, I would not be able to apply because I would have to wait for that information to be released in that report.
Further questions? Sarah, can you give a scenario why you would need another member of the Board of Healing Arts another one specializing in pediatrics?
Yes, thank you, Representative Concanon. Currently, as I mentioned, we have almost 400 child deaths per year that we're reviewing. Some deaths, especially when they're more medically complex or they have law enforcement history or lots of autopsy or toxicology information, a death for one of those could take a board member anywhere from 30 minutes to an hour all the way up to 6 or 8 hours per death. Our 10 appointed board members right now are agency heads, leaders in their organizations, attorneys practicing law. They are doing this on their own time. And to have 10 board members, 400 cases, each of them are reviewing all of those records on about 40 cases per year. Adding that additional doctor to look at some of more of these medically complex cases and also spread the amount of work and records that are being reviewed amongst another board member, I feel would be beneficial to that process overall. And then again, saying that, it also shows the importance of making sure that board members are compensated adequately for their time. Reimbursed adequately for their mileage and expenses, similar to other boards.
Okay, good. Representative Johnson.
Thank you, Madam Chair. Would you object to adding an additional member representing possibly the legislature, since that's not on there, possibly appointed, because then that flows back into our child welfare oversight? I'm just asking if that's something, or if the Attorney General would be objecting to that?
I cannot speak directly on behalf of the Attorney General, but I can say that having a diverse group of professionals to look at these unfortunate circumstances and to help us understand as a state what we can do to prevent future child deaths, I think having a member of the legislature could lend well to that cause. So I can't think of an immediate reason where something of that nature wouldn't be something to consider and appreciate.
Thank you.
Further questions? Okay. Thank you.
Thank you.
So committee, we also have written only proponent testimony from Kay Haug from KDHE, Director of Epidemiology and Public Health. So please take a look at that. I don't show any other proponents. Does anyone wish to speak to the bill? How about neutral? I don't show any neutral testimony. Opponents. I show no opponent testimony. Okay, we will close the the hearing on House Bill 2629, and we'll open the hearing on House Bill 2628 and ask Jesse for an overview of the bill.
Thank you, Madam Chair. Good afternoon, committee. House Bill 2628 requires the Secretary for Children and Families to release certain information when related to a child fatality when criminal charges are filed alleging that a person caused such fatality. So House Bill 2628 would amend a statute generally related to records concerning children. So this is KSA 382212, and it governs access to certain information related to children alleged or adjudicated to be in need of care. Currently, the law states that in the event child abuse or neglect results in a child fatality, the Secretary shall release the following information in response to an open records request. And that information is age and sex of the child, date of the fatality, a summary of any previous reports of abuse or neglect received by the Secretary involving the child, along with findings of such reports, and any department recommended services provided to the child. So House Bill 2628 would allow that information to be released through a request by the Secretary in the event that criminal charges are filed in a court alleging that too much talking alleging that a person caused the fatality. So I'll read that again. So the Secretary will release that information in response to an open records request in the event that criminal charges are filed with the court alleging that a person caused such child fatality. And I'm available for questions.
Okay, are there questions? Committee? Okay, thanks. Okay, we'll open up the proponents and call on Secretary Howard from DCF. Welcome back to the committee.
Thank you, Madam Chair, members of the committee. I'm Laura Howard, the Secretary for DCF, and I thank you for the opportunity to appear here in strong support of House Bill 2628, which my agency requested for introduction this session. As Jesse said, this legislation addresses DCF's ability to release information to the public in the event that there's a child fatality. It's been very important to me as Secretary for Children and Families to be as transparent as possible, and transparency has been a top priority to me. I think transparency and accountability, I think they're essential always in government, but I think they're especially essential to the work that goes on in the child welfare system. Government functions better when it's out in the open and can be held accountable by the public. I requested this bill because I think it's another important step towards increasing transparency while at the same time still preserving important confidentiality safeguards. Certainly the statutes that are being amended here have a number of safeguards to protect the sensitivity of child welfare records and the sensitivity of individuals who may be listed within those records. So what we're asking for here is an additional criteria under which DCF can release information to the public in the event of a child fatality. The current statute, I think sometimes is very confusing both to the public and to our friends in the media and to the public. But essentially the current statute requires a finding of abuse or neglect before we could release that summary information that Jesse referred to. Sometimes making that finding might take an extended period of time. There can be delays in our ability as an agency to make that finding. That most commonly happens when there's a law enforcement investigation that's going on. So we've stepped back, or they've asked us to step back while they are doing the law enforcement investigation. So there could be a lengthy delay before my investigators would be able to make that finding of abuse or neglect. So what we're asking in this statute is we would amend those provisions to allow us to release that summary information upon the filing of criminal charges against a person that alleged that the person caused the child fatality. So if criminal charges were filed, we would then be able to release, again, it's pretty basic information, age and sex of the child, the date of the fatality, a summary of any previous reports that DCF has received involving the child and the findings of such report, and also any services that we had recommended be provided to that child. So essentially, that's what the bill would do. In some cases, this means we would be allowed to release some limited information to the public sooner than we're able to now. I think it would also align with the kind of information that law enforcement would be able to release and the timing at which they could release that information. So again, I ask for your support. I think it's an important part of our stated goal of increasing transparency while also maintaining important confidentiality safeguards. Child fatalities are serious incidents that we all must grapple with. Communities grapple with the impact of that. And I think it's important that there be access to appropriate information really as a matter of public trust. So that's my testimony, Madam Chair.
Okay, thank you. Committee, do we have questions for the Secretary? Representative Wagner.
Thank you, Madam Chairman. Thank you, Secretary Howard, for being here. I guess my question is, so the original law, the reason they didn't release the information was what? Did they think it would be prejudicial against somebody who was going to face trial? Or what was the original rationale behind not releasing the data? Or do you know? I don't know.
I can't speak to the original rationale, but I might speak just a little bit more to the language of the statute. There are a number of provisions in this statute related to confidentiality. For example, there is a specific provision in existing law that you could see on page 5 of the bill, that if a child fatality occurs while a child is in the custody of the state, the kind of information that I talked about would be released at the time of that fatality. The provision we're talking about here is a provision that talks about when child abuse or neglect is the reason for a child fatality, that again, my agency would have the ability to release certain limited information in response to an open records request. And again, that's fairly basic information. There's other provisions in the law. Once there's knowledge that a death occurred as a result of abuse or neglect, there can be requests for broader information. There can be requests for records, and that's in. You can see that in earlier on page 4 of the bill. There's no changes to this that would actually allow requests made for broader records. That's an even more focused process in terms of protection of confidentiality and involves the courts. So in the event of those kinds of reports, DCF would actually have to make notice to any affected individuals, and then courts would make judgments as to whether those records would be released. And I would say that in my tenure, I've not seen a court authorize that release while a criminal investigation or trial was ongoing. I think, again, trying to protect probably, you know, that trial and those pieces. But I would say in child welfare as a whole and federally, there are federal provisions that govern confidentiality that speak very strongly to the confidentiality of those records. Our state statutes, as do other state statutes, mirror those federal concerns. But again, this is a tweak that I think we can make that comports within federal guidelines that would allow my agency to be more transparent for youth not in our custody, where we've not yet been able to make an abuse or neglect finding, but there has been a criminal charge.
Further questions? Okay, thank you, Secretary.
Thank you.
Okay, I show no other proponents, and I show no opponents and no neutral testimony. So unless there's someone else here that wishes to speak for the hearing, I'll close the hearing on House Bill 2628. And I don't think we'll work any bills today. And we are not having our hearing on Wednesday. I'm going to leave the agenda on call of the chair in case I have an opportunity to move one of the hearings from Monday to Wednesday. But you might take note that we are going to have a hearing on House Bill 2772 on Monday. That is the Indian Child Welfare Act that Christina Haswood brought to us last week. And that's a pretty lengthy bill, so I'm giving you a head start on that if you want to take a look at it. And then also, if you recall, last year we had a hearing on House Bill 2189, re-entry to foster care, and that was brought to us by Representative Adam Thomas. I sat on that last year because we were waiting to see where the Soul bill was going to take us as far as the older youth, the young adults. And when we heard the Soul bill and worked it does not address this issue. So we're going to have another hearing on it, just rehear it to remind us what was in it. And then we'll turn around and work those bills on Monday. Those hearings will be Monday, and then that's our last day. So we'll have to do emergency final action. I might give you a couple other numbers. Well, the two that you've heard today, and possibly 2581. I think that's it. I mean, there's the potential of any of the bills that we've heard this year, but those are the ones that I'm looking at right now to work on Monday. So with that, we're adjourned.